For years, it seemed like all anybody could talk about, the Making a Murderer Netflix documentary that followed the story of Steve Avery and Brendan Dassey. Making a Murderer. It impacted millions upon millions of people. If you followed that Netflix documentary or that show, or heard about it, or watched part of it, or read about it, then this podcast episode is for you. Don't go anywhere. Dean Strang defended Steve Avery, and he's here as my guest on this episode of the podcast. He's going to take us behind the scenes, discuss his career, his reaction to the verdict, and so much more. My name is Neil Rockheim. My nickname is the Rockweiler from my unique courtroom style, and this is the Killer Cross-Examination Podcast. And Dean Strang of Making a Murderer is here, and he does Killer Cross. Dean, welcome to the podcast. Dean, welcome to the Killer Cross-Examination Podcast. It's a real honor to have you here. You may actually be our very first sort of like social media star, social media celebrity, if you will.
I'm not, Neil, I'm not on any social media. So.
I know. But, I say that tongue in cheek because over the years, the legal profession has sort of taken on, in some ways, an entertainment value to the general public. And part of that, of course, is with Court TV and Law and Order and, the whole true crime genre. But it's not lost on me, and I'm sure it's not lost on you, that as entertaining as this might be for the general public, we are dealing with real lives and real life implications. And I want to give you a chance to talk about that and what your thoughts are about that.
Well, all that is exactly right. And I think the law as entertainment sort of phenomenon, which is an offshoot of a long existing true crime sort of interest that ebbs and flows historically, waxes and wanes. But I think the law piece of that, courtroom piece of that, goes back at least to the 1940s. Katharine Hepburn and Spencer Tracy, and you start to see courtroom depictions. Television comes along, and very early, by the 1950s, there are police procedurals and shows that involve lawyers. Perry Mason obviously is an early example of that. And that, there just seems a persistent public appetite for that form of entertainment. And, I think at one level, some of that stuff introduces the public to some real issues that we actually deal with in the non-entertainment real life world of criminal enforcement. So, for example, a 10-year-old or certainly a 15-year-old can probably tell you what a Miranda warning is. And, and that's because of watching TV and movies, that kind of thing. But I think also a lot of what's presented to us has a prosecutorial bent, or a sort of statist government perspective, peddles sort of familiar narratives of the police and arms of the government trying to promote public safety and protect the innocent, which don't actually match up all that well with historical experience in this country of what police departments were created to do, what they always have done, and the failings of criminal enforcement generally to produce the public safety that is its stated rationale. So, I think in some ways the entertainment aspect of law helps maintain sort of political narratives of good guys and bad guys, and the power structures that exist, rather than calling those into question on the whole.
There's good and there's bad from it, right?
Mm-hmm.
There's good from it because we allow the public to see what's actually happening. There's the potential for more information, things to take place in public, for the public to see when there's misconduct or misbehavior by prosecutors or judges. But it has another effect, if you ask me. I agree with you. I think that these shows all paint the prosecutor. When you look at Law and Order, the prosecutor is the good guy, willing to, lose a case for the right reasons. And they painted defense lawyer as a guy who files a motion with the blue sheet of paper. I still don't know what that is. A blue sheet of paper at the last minute, arguing some principle, and they paint the defense lawyer as sort of sleazy. And I ask you, I'll tell you this funny anecdote. I remember there was a judge that I knew from years ago. He's since passed away. He told jurors in the beginning, don't trust anything you see on television. That box has been lying to you for years about the way the criminal justice system works. And I know you're a continuing criminal defense lawyer. How many times have you had a client ask you or tell you they didn't read me my Miranda rights? I was arrested without Miranda.
Right.
And of course, I probably tell them what you tell them.
Well, they don't have to unless they're going to question you.
Right. And you can blame television for that, because
right,
when an arrest is not something that it's impactful to the accused, but it can happen in a moment's notice. It's not very dramatic. There's a big announcement when someone is arrested. 1 minute they're talking to the police, the next minute they're in handcuffs.
Right.
But television, to make it pronounced and to make it performative, says, Dean Strang, you're under the arrest for, whatever.
Right.
And then they read in the Miranda warning.
The Miranda card. And
now, you have an interesting story, which I want to we're going to talk about your involvement in Making a Murderer and the Netflix series, because you were the lawyer for, was it Steve Avery, or was it Steve Avery? And that case was a sensation, was a Netflix streaming sensation. Wouldn't you agree with that?
I think so. Yeah. That's certainly.
It was intensely popular. One day everybody's like, have you seen Making a Murder? Have you seen Making a Murder? So I want you to keep that in the back of your mind. We're going to talk about Making a Murder, of course, and your role in it, and what you think you got out of it, and what value there was for you taking part in that case, and the case itself and the litigation. But I want to take a step back for a minute and tell me what led to you becoming a lawyer.
Giving up on editorial cartooning, which is what I had wanted to do from about age 8 until probably my junior year in college. And I made a actually remarkably mature decision as a junior in college. Still stands among the most mature decisions I've ever made, I'm sorry to say, that I probably wouldn't want to be a cartoonist for 50 years, that it probably wouldn't be a good career for me, much as I loved doing it and had thought I wanted to do it for a living. And when I decided, I think correctly and maturely, that's not going to work as a long-term career for me. I didn't have a plan B, Neil. I had been so focused really from age 8 that I was going to be a cartoonist someday that I did not have an alternate plan. But my dad,
editorial cartoonist, as opposed to like having a series like
no, I wanted
before with Beetle Bailey or
No, I wanted to do political cartooning. I wanted to be on the, back when editorial pages of these things called newspapers, which were printed on paper. When the large city and even the medium-sized cities employed a cartoonist, and those cartoons were generally one-panel cartoons on the editorial page or the op-ed.
Of course, you had no idea then that print newspapers would become almost like a boomer kind of generational thing that they would be on the fast. Yeah.
This was, well before the internet. I didn't foresee any of, the disaster that the newspaper industry ran in, journalism in general ran into. I just saw it as, I'm not sure I want to take the job in Fort Wayne, Indiana, because that's where I get my first job, and then try to find a syndicate. And then, now Buffalo, New York is looking for a cartoonist. And well, then I'll go from there to Denver if I'm lucky, or Seattle. I just didn't see myself wanting to hopscotch the country, chasing larger circulation newspapers and bigger syndicates for the long haul. And also decided, what the cartoonist is doing, and it's valuable, it is valuable, is pointing out a problem, using satire to capture a problem and draw public attention to a problem. But the cartoonist is never offering a solution. Cartoonist is never part of the solution to the problem, really, other than the initial work of framing the problem. And I thought, I think I'd like to do something more collegial and where I can choose where I want to live, and drop roots and help try to solve problems at some, in some way if I can. And so I had no plan B, but my father had always had a plan B. He wasn't enthused about the cartooning idea. He saw it as doodling. And his older sister was a lawyer and was the star of his family and our larger family. She was the brightest, really the brightest person in his family. And none of them were dummies, but she just stood out. And she had this inspiring story of having gone to law school in 1949 as a woman, and battling the sexism of her day and overcoming, and had established a very successful law practice doing estate planning and trust and probate work in Chicago. And to my dad, to his way of thinking, smart, articulate people who could write well and read well, they became lawyers because his sister had done that. And so he had always sort of pushed me on that, in that direction, unsuccessfully, until I abandoned the cartooning plan. And that wasn't because of him, actually. I made that decision filtering him out. But once I dropped that, and now I'm a junior in college, and in a year and a half, I've got to do something.
Did you have a romantic view of lawyering and what it was like to be a lawyer, or is yours more pragmatic?
It was much more pragmatic. My model for that was my aunt, who, as I say, had a wonderful law practice that was important to her, but it was a large firm, doing estate planning for relatively moneyed people, and then working with families after a death. You know, she was empathetic and had good skills in that regard. But to me, it was a very pragmatic.
So you didn't enter into it with the idea that I'm here to save the world and I want to be
No.
center stage. And
No, I really wish I could say that I did, but I'd be lying. It was pragmatic. It was, from my father's perspective, a way to make a good living, which was important to him, that I, be able to make a good living. And I didn't know what I wanted to do with a law degree, because I didn't intend to be a lawyer until, as I say, about a year and a half before I showed up at law school.
so when you entered into law school, did you have some idea of what area of
No,
law you wanted to practice?
all I knew is that I never wanted to be in a courtroom. That's what I thought I knew.
Well, so you're not editorial. I'm just gonna. So you're a great courtroom lawyer and one of the most respected courtroom lawyers I know. So you went from, to summarize, you went from wanting to do editorial cartoons where basically you would offer your opinion, not anonymously, but without really ever having to face the people that were reading them, right? I mean, because you didn't do it like in front of them.
No, you got hate mail.
Right. But I mean, it's not like as you're drawing it, someone saying, what are you doing?
Right.
To becoming a lawyer, not wanting to be in a courtroom, to now being a fantastic courtroom lawyer. So tell me why did you not want to be in a courtroom?
I just thought I wouldn't have the personality for it. And indeed, I'm conflict averse in many ways. I don't enjoy conflict. It's not natural to me. I'm not a terribly combative person, really. And I thought I would not like the adversary process, that I'd be more happy, again, sort of problem solving for people and writing, doing sort of softer advocacy and service with people. It didn't work out that way. And, and I don't consider myself a terribly good trial lawyer, honestly, or, I know better trial lawyers than me. I know a bunch of better trial lawyers than me, but I did find something valuable in going to bat on behalf of somebody. And I will say, I have never liked bullies. I don't like bullies and bullying. I've been an underdog kind of guy, and that does go way back. So once I sort of got in touch with that, or figured out that there's a large part of me that really likes to stand up for the underdog, then it became easier to think about going to court. And I've never been afraid of public speaking. That's never terrified me. I had to grow into it, and we all get better as we go, but the prospect of public speaking itself never terrified me. So,
how did you get into? So let me ask you this question. When it sounds like you almost, in a way, if you can think of the movie The Blind Side, where Michael Oher ends up getting in touch. He really wasn't one of those guys that went to the football field with a lot of anger. But when he got in touch with, if you accept this, part of the movie, his protective, tendency, his habit or desire to protect the people who he's around, he was able to channel that feeling into being an exceptionally good football player. And as you're telling me your story, I'm hearing something similar to that as you were able to tap into the feeling of sticking up for the underdog and bullying, that you were able to channel into that, and you use that as additional motivation, or as to help you find your voice in the courtroom. Is that about right?
I had never thought of it in exactly those terms, but I do think you're about right. That sort of instinctive siding with the outsider or the underdog or the despised, that's been there forever. And it was sort of realizing that, coming to recognize that, and then find a way to turn that into a day job, if you will, into a living, into a vocation, a way of being.
I mean, the words you used are almost I think a Clarence Darrow, I think there's defender of the despised. I mean, you have to do this job, you have to sort of be able to attempt to not judge your clients and to try to find something about them and their story that you can empathize with. And many of them are underdogs and many of them are up against the system. So I give you a lot of credit for that. How did you develop your style in the courtroom?
By watching people who are better than me. I got really lucky, Neil, in having as good a mentors as Wisconsin could offer, and I could, I think as good a mentors as anywhere could offer. Jim Shello was and is my principal mentor. He's about to turn 95 next month. Steve
God bless
Glynn,
him. Yeah.
and a number of other lawyers who have been kind to me and allowed me to tag along or learn from them. And now, to be sure, you have to find your own voice. And part of the beauty of the mentors I've had is they never tried to force me to emulate them, or to try to copy what they were doing or saying or how they were doing it. They simply inspired me to, develop to be the best lawyer I could be, and showed me a model of what, running with your own skills and trying to develop who you are can be, and what it was for them to become really.
So how would you describe your courtroom style? I'll give you some examples. So I asked Sarah Swain hers, and she said that lethal. I asked Jeff Lichtman. He said smothering. He likened his cross-examination style to a full court press where he just, constantly in someone's face. How would you characterize your style? And if you have a different one today, how did it begin and evolve?
I don't think it's changed radically over time. And I probably would choose words like reasonable and even bookish on occasion. Certainly with judges, I tend to be on the bookish side, certainly for criminal defense lawyers, especially as a group. But I think reasonable is probably the persona I feel most at home in, or the feels.
You have a very believable look. Roy Black was once described as having an affidavit face. He goes, it's a good thing. I said, it's a very good thing if you're a lawyer.
I like that. Yeah.
And I would put you in that category. You have a look of someone who is gonna be truthful, which is, sort of gets you over the hurdle of the lawyers that have the appearance of, when they walk in with a $2,000, silk suit, who look like, they're trying to sell the jury something.
Well, and I mean, that's right. I will never be Albert Krieger with his sort of physical dominance and just charismatic presence. I will never be Gloria Allred with the presence that she has. Really, I had good advice and again, good mentors who would have dissuaded me immediately from trying to be inauthentic, from trying to be something other than what I was. Rather, I was encouraged to find value in what I could do and who I was, and then to become the best version of myself I could be.
We're going to get to the making a murder stuff, I know, but tell me a little bit, if you don't mind, about how would you advise young lawyers or lawyers who are still trying to find their way in the courtroom? So many programs, lawyers, books tell people to be themselves, but they don't really say what that means. You know, like if you're sarcastic, don't be sarcastic. But if you're funny, don't be funny. But don't be boring. Don't be aggressive. But you can be aggressive, but don't be too aggressive. You know, how do people find their voice in the courtroom?
Well, I think the same way you, in a sense, find it anywhere in life. You got to figure out who you are, and that's not easy. You know, many of us never really do that. So I think that, not in a self-absorbed way, but that process of sorting out what are my skills, what are my gifts, and what are not my skills and my gifts. You know, what do I have to admire in others, but realize I don't have? And then let's focus on what I do have. And I think that sort of self-awareness, as you develop it, ideally, then should play itself out in allowing you to establish authenticity.
Well,
not fake authenticity.
right, I know. And you
contrary,
get the people that go in there and they want to be Jerry Spence, and you're like, okay, but you've never set
You're
foot
not
in
Jerry
Wyoming, so
Spence.
don't be Jerry Spence.
No,
It's
you're
not going to
Jerry
work.
Spence. And you don't have to be Jerry Spence. You don't. You get to be, Neil. You get to be Dean. You get to be, Sarah, whoever you are. And if you work on being that and developing authentically who you are, just as you value authenticity in other people, they're likely to value it in you. And you then can be believed. And, persuasion fundamentally is about connecting with other people in an authentic way and with integrity, and then enjoying being believed because you're worthy of it, because you're worthy of
Those are
belief.
great points. And I think that last part is really, really, really important, which is to strive to be, you can get to a point where you are competent and effective because you're worthy of being believed. Not that you're worthy of having attention or of having people look at you and say, wow, what a aggressive, powerhouse, but you're worthy of belief. I think it's not something to strive for. It's something to find. And the only way to find that is what you're saying is you have to know yourself. Jurors will pick up on someone that does. Jurors will pick up on somebody who is just totally, losing their shit in there because they are not confident in their ability with their knowledge of the materials or in their ability to get, to figure out a way to get the witness to reveal them.
Well, and let's face it, if you're doing criminal defense work, jurors are expecting you to lie to them or to be deceitful or manipulative or less than fully candid. They're expecting that. They've watched Dick Wolf's TV shows, they are expecting you to be an obstructor of justice rather than a disruptor of injustice. And so, the first time you lie, you're simply feeding into what jurors are already conditioned
so
to
astute.
do.
Such an important point. The burden of proof is supposed to work in favor of our client. Our clients are presumed innocent. But in my experience, the prosecution witnesses can be impeached, contradicted, can admit to be wrong. They can have holes in their story. They can be contradicted with logic and facts. The prosecutors can misstate something. If you or I do it, or our witnesses do it, or God forbid the accused does it on the witness stand one time, it's like, write them off.
It's over. It's over. Yeah.
So this is probably a decent point for me to transition into how did you make the decision? Tell me about the Making a Murderer, the I know the series. Tell me about the case. How did you get involved, and how did you make the decision to get involved in not just the case but in the show?
Well, I'm glad you distinguished that, because the initial decision was, do I get involved in the case? Um, and at the time I had to make that decision, I had been told by the two civil lawyers whom Stephen Avery had representing him in his civil action against the county. I had been told, hey, there are these two young filmmakers. They're students, they're graduate students in film school, and they're hanging around. They're around, and they're trying to shoot a documentary as a master's thesis project for school. So be aware, that they're going to be around. They've been here. They've won the family's trust. They're part of, the scenery, so to speak, or part of the environment that you'll be in if you take the case. I had been warned about that. And I got in knowing that they were out there, and having heard good things about these two filmmakers generally from the civil lawyers, who thought they're bright, they've been straight with us, they've been honest, and they seem to have sort of a worthwhile perspective they want to bring to this. But just be aware, Dean, there's people floating around with a camera if you get into this case. And so I got in knowing that. And then shortly after I got in, and I talked Jerry into joining me, Jerry Buting, we met the filmmakers for the first time, because we went up to the Avery salvage yard to see the sort of the scene, if you will, and meet Stephen's family members. And the filmmakers were there. I didn't know they would be, but they were there. I'm sure because, either Alan and Dolores Avery had told the filmmakers, or some member of the family had. And so we got a chance to meet the two filmmakers very shortly after we both got into the case. And I was impressed with them. They clearly were bright. They clearly had won the trust of the Avery family members by being trustworthy. And my initial interactions with them were good. I thought that they were candid with me. I thought that their project sounded worthwhile and not lurid.
What was the understanding of the focus of the project when you got in?
When I first got in early 2006, the focus, as I understood it from the filmmakers, was, yeah, we're making this film, this documentary, as a, because we have to graduate. But what we're really interested in is, okay, so Stephen Avery had this remarkable experience of doing 18 years for a crime that another guy committed. Then he gets exonerated by DNA, and that in Wisconsin causes this effort to re-examine the criminal enforcement system. And, a commission gets appointed, which gets nicknamed the Avery Commission after him, to look at reforms, legislative and otherwise. And then there were some reforms made. Then, 2 years later, here he is, he's back in the criminal justice system. And what the filmmakers wanted to ask, or invite the audience, to the extent they had an audience someday, to ask is, well, what changed? Did Avery get any of the benefits of the reforms that were made in his name, or the rethinking of some of the weaknesses of the system that his own earlier exoneration caused? Would he see the benefit of that the next, now that he's back in the system? And I thought that's an intelligent question, to ask. And they were very clear that they didn't want to answer the question for viewers. They saw their job as documentarians to sort of provide eyes for the viewer to see the process, see behind the scenes. That made a lot of sense to me, and I thought it had integrity. And so then the question was, well, are we going to cooperate? Can we cooperate without violating the lawyer-client privilege, or running afoul of disclosing confidential information under the rules of professional conduct? And there, the fact that Laura Ricciardi, one of the filmmakers, was herself a lawyer. She had, before film school, she had gone to law school, Northwestern. I mean, she went to a very good law school and had practiced law for a little bit. That was really helpful, Neil, because, Laura immediately, I get it, lawyer-client privilege. I understand that. I am one. I am a lawyer. I get that. We're not looking to violate that. And we're not, looking to get our hands on confidential information or, to either aid or undermine your defense. We want to be sort of eyes in the background.
Did you have to sign any agreements that with them or with you that none of the material would be used until a certain point? Did they?
No, it's funny you're asking that, because I asked you, that was the next question I had. First of all, was what are you guys up to? And,
Right.
can this work with the professional obligations we have to Steve and to, the rules of professional
I mean, in the
conduct?
way my files come together, I know that the hot dog and at the end looks pretty good, but you watch us put the case together, you know what I mean? And it's a series of,
Yeah.
you know what I mean? I don't know, you want to watch us assemble it.
Well, right. And one thing I did know, again, coming back to ethical obligations, is I couldn't be involved in something that was going to get sprung on either Steve and Avery's jury pool or Brendan Dassey's jury pool before they were tried. Any sort of a film being put out there before these cases went to trial would involve me in, providing information that could taint a jury pool. And so I really was asking the question you just asked of them after we got through the lawyer-client privilege stuff and the what are you up to stuff, is, hey, how do I know you're not going to put something out there before these cases go to trial? Because I can't be involved in that. And Jerry and I, were saying this jointly to them, and they sort of laughed and said, well, it's obvious you don't, less about filmmaking than we do, because that's just now how it works. This, we're going to shoot until these cases are over. The story we're telling has to go through the trial. And then there'll be a whole, I think they called it post-production. There'll be a whole period in post-production, and that could go months. I don't think they even realized it could go years, which it did in the end. But, there's a whole post-production process. Dean and Jerry, there is zero chance that we would put anything out there before Stephen and Brendan's cases have been tried. And so, once we understood that and were satisfied by those answers, then, the answer was, we're willing to cooperate with you. And we'll take it a step at a time. And if you chase us around with a camera or show up unannounced or, or break your word to us, this is going to end pretty quickly.
Were there moments where you were filming, or they were filming, I should say, and you didn't want them to film whatever you were doing, or you had to tell them you can't film this, or did you get to a point where you sort of didn't even pay attention to them being there?
No, we always paid attention, and they're very much were, of course, there were conversations and, stages in our work that we could not have somebody filming. no matter when it was going to come out. And they were really respectful of that. Again, Moira is very bright, and Laura is both bright and a lawyer. So they got it. We did not have to come close to beating them over the head about this. Not even close.
So
Quite the
fast forward to the trial. So what was the trial like? Let's start there. What was the trial like? As you went through it, the cameras were obviously in the courtroom. So what was the trial like?
Well, the cameras were actually unobtrusive, Neil, because the case was tried in a recently renovated courtroom that was set up with a media room in the back. So, if you think about in a modern or recently renovated church or temple, there's often a room in the back of the sanctuary for moms, nursing moms or moms and, parents with young children, where there's a window into the sanctuary, but it's soundproofed, and the sound from the sanctuary is piped into that room. And that's what the media room at the back of the courtroom that we used for Stephen's trial was like. And the judge ordered that all of the interested media, these two filmmakers included, but mostly local and national networks, all of them would have to share one feed. He was going to allow one camera in that media room. And then there were mounted ceiling cameras in the courtroom that could be remotely controlled, just like surveillance cameras that you'd see in a bank or almost everywhere these days. They were ceiling mounted, and they could be controlled remotely. And so the judge said one feed, and the media folks could pick one person to run the camera in the back that would be filming from the media room and would toggle the ceiling cameras with rules. Can't film the jury, can't listen in at counsel table for either set of lawyers, and so it really was much less intrusive than would have been a highly covered trial in, say, 1990, where you actually had tripods in the courtroom and, cables duct taped to the carpet on the courtroom floor.
I had a trial that was right. Just like that too, as a matter of fact, not too long ago. And, you go try to find the angle you got to weave your way around the wires and the cords and
we had none of that. That's exactly right. And we just had none of that because the courtroom was equipped for the media in this respect. And the judge, I think, had the good sense to say, one feed, you're all sharing it, and you media people decide among yourselves who's going to run the camera.
Did the jurors know through voir dire or judge-directed voir dire that there was a documentary that was being made of the trial or of the cases, I should say?
No, they did not learn that from the judge, and I don't know that they would have had any way to know that. The jurors certainly knew, because they lived in Wisconsin, that this was getting massive media interest.
It was as big a case as there was in Wisconsin at the time.
Absolutely. Right? It was the biggest case since Jeffrey Dahmer.
And do you attribute that to, well, I ask you, what do you attribute that to?
Well, we could go on for a long time about that, but Steve Avery was a household name because of his 2003 exoneration. And this all then happens just a little over 2 years later in the fall of 2005. So he's widely known. And then, you had also here, and I trust you'll understand this is not directed at Teresa Halback or her family or, you know, the victim, you know, any victim, let alone Teresa Halback. But you had missing white woman syndrome. You know, this was a young, attractive white woman who went missing. And we've just been through that again, rinse and repeat in this country, that, you know, when women who are white and young and attractive go missing, it gets a lot of attention. And
Dean, there's nothing, look, let's be straight. That doesn't take anything away from the tragedy of a person going missing or dying.
Of course not.
We point that out, and I pointed that out recently about Gabby Petito when I was asked, why is that case garnering so much attention? And of course, there are Indigenous, Native American, Indian, and I mean Indian of, you know, from India, Indian. There are women of color. There are African American women who have just simply disappeared or vanished, or who have been, you know, unceremoniously murdered and recovered, you know, months, if not years later.
Nary a blip.
No, you couldn't.
You don't see it on TV. You don't even read it in the
conversation. And someone said, "You believe it?" I said, "Yeah." Name me the most recent case of an African American woman who garnered so much attention was Breonna Taylor, and that was for a whole different reason.
Yep.
Right. A whole different reason.
Right.
And not just about who was purely, you know, victimized. And so there's nothing wrong with you saying that, and you're not taking anything away from the tragedy.
No.
That's a fellow person.
Yeah. And I don't think I'll be misunderstood in that respect. It just, there is a reality that, you know, merely asserting in the United States of America in 2021 that Black Lives Matter, you know, draws reaction, draws controversy.
Right.
And, you know, but in this country, blonde lives always have mattered, right? I mean, that we've always taken for granted.
It's
and
the difference between, to put it into,
but you see the point,
between Cinderella disappearing, right? And everybody goes to Disney World to see Cinderella, right? I mean, everybody goes there to see Cinderella. Cinderella's castle, Cinderella. It's the difference between Cinderella disappear and the difference between seeing Mulan. And I'm not, again, downplaying that, but if you were to ask people, what cartoon have you seen? Everybody's seen Cinderella, right? Everybody.
Yep.
Everybody's seen it. I bet you that not half of the people that have seen Cinderella, I'd be happy to be proven wrong if half the people who have seen Cinderella have also seen the movie Mulan. Just because I'd be impressed and happy that many people chose to see that movie. So I get it. So what other factors played into did Steve Avery, the fact that Steve Avery was involved and he had just been exonerated, did that play a huge role as well?
That was a huge piece of this. Again, because he was a household name at the time in Wisconsin. And, you know, and there was a backlash against him. Boy, you know, he may have been innocent of that rape in 1985, but maybe we should have just left him in if he was going to get out and kill somebody. You know, there was immediate assumptions that he was guilty. And just
all right,
you
so
know,
Dean, how did you get, if you are able to verbalize it, how did you attempt to turn the table, if you will, so that Steve Avery got everything our legal system has to offer? Now, we're not judging whether he's a good guy or a bad guy. It's not what the system is about. It's about whether or not we can, you know, we're trying to apply the golden rule, which is we start with the belief that everybody didn't do the thing they're accused of, believing the best in the people who are on trial, and then they got to prove that they're not entitled to that. So how do you deal with that? How do you talk to the jurors? How do you deal with that in opening? What kind of
it starts before the jurors. I mean, Jerry and I made the decision that we can't tell the media simply no comment. We have to have a thoughtful, ethical media strategy that will involve talking to the media in appropriate ways to push back on the state's narrative, which had been put out there during the time Teresa Halback was missing by the sheriff, by the special prosecutor, and that continued after Stephen's arrest until shortly after Brendan Dassey's arrest.
I mean, it sounds like deja vu. I mean, we're having this conversation as it's literally playing out that way in the media related to Gabby Petito and Brian Laundrie. So again, not passing judgment on the case, just people that want to suspend. I want to suspend civil and constitutional rights. I'm reading articles of people that have blue check marks next to their name on Twitter, and they are, civil rights advocates. But here they want, why do Brian Laundrie's parents get to speak through a lawyer? I mean,
yeah.
So, okay. So how did you keep going with that? Because I'm interested in that. How did you try to shift the narrative?
Well, by thinking through in advance what we could say to the media and what we should say to the media, in offering a counter narrative, or at least asking people to withhold judgment on the prosecution narrative. And we also carried that out with, written motions and briefs. You can say what you want in a court filing. And so we briefed motions, and we wrote both motions and briefs with a view to making them readable for, the news media. This wasn't focused on the documentarians. This was focused on the media, who nightly were reaching every major media market in the state.
And you picked up on something. You noticed that I've shifted in what we're talking about, because as I pointed out, you have a case to try.
Yep.
I mean, they're doing their documentary.
Yep.
But you got a case to try.
I'm not making
what
a
you
film.
have to do to defend your client, right?
Yeah, I am not making a film, and and I've said this before, and I'll say it again bluntly. I thought nobody would ever see the film that they were making. I assumed their
you were wrong about that.
I thought their classmates would see it, or look. I mean, Neil, at the time in 2006, and then the case gets tried in early 2007. At the time, to me, a documentary meant an art house cinema, 15 people in the audience, hour and a half or 2 hour movie.
Questions afterwards, right?
Right.
Never did you think that Netflix, which was, never would have. I didn't know Netflix was even going to. Who knew Netflix was going to blow up this big?
Neil, at the time in 2006 and 2007. Netflix was mailing you DVDs of movies in red envelopes
in the grocery store.
That's what Netflix was. They weren't making original content.
Unbelievable.
They were mailing you movies that you said you wanted in the U.S. Postal Service, and we were a year away from smartphones when this case was tried.
Did you voir dire? It's an unbelievable story. Not unbelievable. It's fascinating. Just each of the things we're talking about could be covered, at length, because they're so fascinating. But to me, tell me about the voir dire. Did you get voir dire in the case, and did you have a chance were you able to work in any of the things that we're talking about, media bias, about don't prejudge, and if so, give me a couple examples if you can think on the fly about what you said and how it turned out.
We had a week of voir dire. The judge allowed individual voir dire. Liberally,
which is great, by the way. Good for the judge. Fantastic.
Yep. Kudos. And I can't remember now. That was 2007. It was more than 14 years ago, but I can't remember now specific questions. But sure, absolutely, we were trying to get at: do you have an opinion about whether he's guilty or innocent? And indeed, there had been a jury questionnaire that the defense and prosecution had written collaboratively, had agreed on, and the judge had blessed and sent out, that asked a number of those questions. So we had completed questionnaires from potential jurors before that week of voir dire. And then the voir dire was sort of trying to drill into that and get at whether whether people were willing to listen to the evidence and make a decision on what they learned in the courtroom rather than what they'd seen, on Channel 5, or Channel 2.
When Making a Murderer came out, when the Netflix series came out, so many people seized on that as a way to, it was one of the first times that I had heard lay people, people who just kind of don't pay attention to what happens in the legal system until it affects them, talk about the injustices that they observed in the case, some of which were related to interrogations, the Reed method, the expert testimony. And I wanted to ask do you think that those lessons from that case have still sunk in, or has too much happened in society? You think that we're getting away from that now?
No, I think Making a Murderer and other, thoughtful, well-made documentaries that have come out either right before or since have continued to resonate in some ways. I mean, we've seen real change in now several states in the way juveniles can be interviewed in custody by the police, legislative change. We've seen, I think, broader social conversations about the role of prisons and the role of the police. And yes, George Floyd, and a growing recognition that people of color, especially, are killed by the police, often with impunity or without serious consequence, have been a part of that. The advent of the smartphone and the ability of every citizen, every person on the street to become a filmmaker, an amateur filmmaker on a moment's notice, has been a part of this, to be sure. But I do think that, Making a Murderer and a number of other thoughtful documentary treatments have had some resonance, both in this country and to an extent around the world, in at least broadening the number of people who are questioning the reliability of our criminal enforcement apparatus, or the criminal enforcement apparatus in their country.
What do you think about, so one of the things that I've harped on a lot is in my career and in the cases that I've handled is the Reed technique. To me, it's insidious. That's my opinion. I think it has the capacity to it's designed, from my understanding, to completely shift in the accused, the person being interrogated, how your defense mechanisms, which are designed to typically defend yourself from accusations, for those to be used against you, and for your desire, to feel the relief of guilt by agreeing with law enforcement. It's psychologically insidious, and we've tried to challenge it every which way. When you went into the case, what was your knowledge about the Reed technique and interrogations, and what did you come out of that case thinking about it?
Well, I went into it with essentially the views you've acquired through professional experience and an understanding generally of the Reed technique. It's the most familiar of the group of confrontational interrogation techniques, techniques that are based on confronting the person who's professing innocence and trying to cave that in, trying to end the protestations of innocence. I came out of it with, for me, what was my first really vivid videotaped experience of the Reed technique being both applied and misapplied against a juvenile, a kid, a 15-year-old who had learning challenges. You know, videotaping police interviews was relatively new in 2006. Audio taping had just become required in Wisconsin in the late 1990s, very late 1990s, thanks to a Wisconsin Supreme Court decision. And videotaping was quite new. So we were in the early years, Neil, at least in Wisconsin, of having an audio and then eventually audio and visual record to rely on rather than a police report, a typed police report. And so, you know, Brendan Dassey's experience with the critical interview and the one preceding that, for that matter, was captured on video, was available to us, and really was not my first look at a videotaped custodial interview, but my first look at one in which Reed was both applied aggressively and misapplied, you know, where they went beyond Reed and were doing it as to a juvenile who was unsophisticated.
And there are people that have absolutely watched that interrogation and they're sickened by it.
Yes,
you know,
I'm among them.
Physically sick.
I'm among them, and it's wrenching to watch that. And I'll tell you, I mean, my view of the Reed technique really at a sort of an overarching way is, okay, look, it's a confrontational technique. It starts with a police officer simply deciding, based on 1940s and 1950s behavioral psychological norms, whether you're telling the truth or not, you know, whether you're guilty or you're not guilty. And if the police officer decides you're guilty, then we have an array of psychologically manipulative techniques that can be used to overcome your false denial of guilt. So I would say this to you, Neil. If you believe that human beings are reliable truth, you know, detectors, are reliable lie detectors, always, and if you believe that when somebody's in custody, there is no power imbalance between them and trained police officers who, in Brendan's case, were old enough to be his father, then the Reed technique's terrific. You know, but if you believe that humans are accurate lie detectors and that there is no dangerous power imbalance in a police interview room, then, you know, then you're likely to believe a whole lot of things that also aren't very believable.
Right. Well said. So, tell me a little bit, because I would love to talk to you all about the cross-examinations in the case and everything else. But tell me, if you would, when the verdict came in, what was your reaction? And have you had any feelings that Steve Avery was he close to being released, or did you have any optimism after that as the case wound its way through the appeal courts? So start with the verdict.
I felt, I can feel physically how I felt. When you bring that up, I can relive the physical feeling of having a hard time breathing. You know, just having a hard time breathing, feeling like my stomach, you know, was full of something, or had, you know, just feeling physically ill.
People don't realize that when we go through a battle like that, again, obviously the client is the one that, you know, has to do the time if they're convicted. But we are, I mean,
well, and it,
take years off of your life, right? I mean, you're taking years off of your life with every every jurors. I've seen friends of mine that are waiting for juries and they're reading a book. And I look at them like, what are you doing? How can you read a book? I'm listening. I'm hearing the floor creak in the back and wondering what's going on. You know?
Yeah, no, I mean, you get to know a client, or you should. And if you're an empathetic human being, by the time you're sitting next to somebody who's about to find out whether he's going to spend the rest of his life in a cage, um, if you aren't emotionally involved in that, you're a different person than I am. And whether it was a sense of rage or despair or defeat, inadequacy on my part, probably a mixture of all of those things. I just remember having a hard time breathing after that, as that verdict was read and after, and looking at Stephen, sort of just turning further within himself. And then knowing I had to go downstairs to the basement and talk to the media after that.
Gut wrenching. I can see as you're talking, I can see the pain and having to relive it. It's takes a lot out of you, you know?
I think it does. I mean, I actually think it does it takes something out of you and away from you. Now, this job also gives you things back. You see moments of grace, dignity, strength,
Salvation. Yeah.
salvation. And on those rare occasions when we really win something, boy, there aren't many things that feel better, right?
I agree.
But
I had a case that I tried
the
and
losses are hard.
The losses are hard. And I know that there are many lawyers that go around there and pat themselves on the back and say that they have not, lost a case. And I tell them, then I know that there are some folks out there that claim that, putting aside Jerry Spence, who's had a once in a world existence career. But for those of us that try these cases all the time, you're talking about, even Jerry would say, I mean, he's tried 48 criminal cases in his life. And you're talking about people, there are defense lawyers who try 48 cases in, in 2 years.
Yeah.
So, I can see the difficulty. We all have it. You get done with a trial like that and it's just in your gut and you're sitting around and you question your existence and you wonder whether you should power up again. You know what I mean? And how do you power up again?
Yeah, no, that's right. And I think, again, I will readily agree that there are many better criminal defense lawyers out there than I.
Wouldn't
But
say
if
that,
we're going to be honest with ourselves, all of us, no matter how good we are, if we're going to be honest with ourselves, we do a lot of losing for a living.
Yeah. So let me ask you a little bit. So no, the focus of this podcast is normally on cross-examination and trial tactics. So let me ask a couple of things just along those lines. So, and I wanted to talk to you about the Making a Murderer, case and the Steve Avery case. Did there come some point subsequently where you had hope that Stephen would be released in this case, or that he would win an appeal, or no?
I still have hope about that. I think it's a realistic hope, meaning that the odds are long against him, but I also don't view it as hopeless. And I think in some ways, this probably is echoing something Stephen says in Making a Murderer, which, roughly, which is, the truth is a hard thing to keep bottled up forever. It has a way of getting out eventually. And I think that the truth ultimately here will be Stephen's ally. I really do believe that. And so, I do not dismiss the long odds he's facing, but he's got a lawyer who's given it everything she's got, continues to give it everything she's got. And, you know, I remain hopeful.
Okay. Sort of a speed round here, because what's your favorite part of a criminal trial? Voir dire, opening, cross-examination, direct examination, closing. What's your favorite
Cross.
and why?
I feel most in control on cross. And it's the primary way that I'm going to advance a defense narrative in almost every trial. In fact, I could take away the almost in every trial. Even if I'm putting on a defense case, cross is still the first, and therefore, in a real sense, the primary way that I'm advancing a narrative of innocence, or, you know, of absence of guilt. And I enjoy the craft of cross-examination, which isn't to say I'm the best cross-examiner you'll ever meet, but it is to say I enjoy it, I prepare for it, I'm relatively comfortable doing it. I'm least comfortable doing voir dire. That's always the hardest part of a trial for me. You know, for me, sure, closing's fun, but if you haven't done your work on opening and cross, closing is bluster. You know, closing is just so much theater if you haven't developed a narrative factually through cross-examination that the jury is geared to hear because of a well-done opening.
What's your favorite cross story?
My favorite cross story isn't from a criminal case at all, and it's a disastrously bad cross-examination that I did. Very early in my criminal defense career, probably a year in to doing criminal defense, Jim Shello, for whom I was working, took me down to Las Vegas to represent him and two other criminal defense lawyers, one from Chicago and one from Beverly Hills, in an adversary action in the bankruptcy of the Aladdin Casino. They had represented, Jim and these other two lawyers had represented the Aladdin and people associated with the Aladdin in a well-known criminal trial back in the early 1980s. 6-month trial, they'd secured acquittals, and then they didn't get paid. And when the Aladdin eventually went into bankruptcy, they filed claims as unsecured creditors. And that adversary action in bankruptcy court in Las Vegas finally came to trial in the late 1980s. These three old war horses didn't want to throw more money, you know, good money after bad by hiring someone to represent them. So they talked 28, maybe 29-year-old Dean into representing the three of them in this bankruptcy action, because I'd had, after all, the vast 2.5 years of experience at a civil firm. And so here I am. I'm a kid compared to my three clients, these accomplished criminal defense lawyers in their 60s at that point. I've got next to nothing in the way of discovery. And the cross-examination story was that my clients, and I'm not disclosing anything that didn't come out in federal court in the adversary proceeding in bankruptcy, but my clients had said that an oral promise to pay fees had been made by Aladdin Hotel management in the presence of Wayne Newton, who was a minority owner of the hotel and casino, in his suite at the top of the Aladdin at the time. That's since been torn down and rebuilt, but the old Aladdin, they had this story that, you know, they'd had this meeting in Wayne Newton's suite, and representations about being good for their fees by the company, the corporation, were made, and that Newton would have overheard these. Wayne Newton would have. So we were going to subpoena Wayne Newton, and I was going to, do a cross-examination or an adverse examination of Wayne Newton with nothing to impeach him with. I had no statement from, Wayne Newton. We hadn't taken.
Didn't you say no? Isn't it true that you said you heard no? You sure?
There you go. There you have it. And we had subpoenaed him to court at 9 a.m. or something, and some employee or bodyguard or somebody employed by Wayne Newton came to court sometime after 9 saying, Mr. Newton doesn't get up until noon or something like that, and nobody is going to get him up early to come to court. And the judge took his side. The judge said, that's right. He doesn't have to come to court until the afternoon.
I like it. The Wayne Newton exception to the subpoena.
In came Wayne Newton with this phalanx of lawyers and accountants and, his entourage at some point in the afternoon. And he cuts an impressive figure. He's a tall guy. He's elegantly dressed. You can tell he's a personage, so to speak, right? Or you could at the time. And he comes and looks at me as if I was something he, stepped on and gotten on his shoe. And there went the cross with nothing for impeachment, no prior opportunity to take his deposition. It did not go well, Neil.
I can only imagine.
At all. And I thought, here I am. I'm a year into working for Jim Shello, and I'm taking an enormous belly flop in front of him and 2 other really prominent criminal defense lawyers.
And Wayne Newton.
I'm toast, and Wayne Newton is eating me alive. And he did.
That is a great story. Okay. Last couple of questions. Who is your favorite? In your opinion, who's the best cross-examiner you've ever seen? And you have to exclude yourself, because I've had people say, they always say me.
It's not I. When he was really on, Jim Shello, on his best days, was the best cross-examiner I personally have seen. I think that day to day, allowing for the fact that lawyers have good days and bad days, the sort of mean was highest. The couple, 2 or 3 days, I watched Mike Tiger in the Southern District of New York, representing a client who was accused of giving material aid to the blind sheikh, was tried by the federal government. A CJA panel lawyer who was put on trial essentially for work she did on behalf of her client.
I remember that case.
Mike Tiger represented her, and that was a sense of a surpassingly good lawyer on every day. On his worst day, Mike Tiger was capable of controlling a courtroom, articulating an argument, framing a question, and focusing the narrative in a way I couldn't possibly emulate. Just extraordinary, Neil. It was, so I saw a lot of Jim Shello, of course, in my life. And, Jim is an artist. On his great days, Jim was an artist and made the rest of us really look like we were painting by numbers, or trying to color inside the lines in a coloring book. I thought Mike Tiger just was a lawyer for all seasons, so to speak.
Amazing, great description, and what a testament. So last question, if you could cross-examine anybody, dead or alive, who would it be?
You gotta give me some warning of these. I'm not that quick.
Well, that's the whole point. I
Not
think
that
about
quick
it
on my
now.
feet.
Dead or alive, who would it be?
Well, the one who comes to mind at the moment, at top of mind on that list, would be the 45th president of the United States, Donald J. Trump. I think that would be a fun, tough, roll up your sleeves cross-examination. I think that I also would appreciate cross-examining Clarence Darrow.
Interesting.
I'm a huge fan of his. I regard him as flawed and wonderful and human, fully human, and extraordinary as any lawyer I know anything about. You know, a saintly sinner or a sinning saint or something like that, but just a fascinating man now, you know, 83 years after his death. And it would be wonderful to have a chance to do, ideally, a relatively friendly cross, but you know, but have the chance to ask leading questions. Let me put it that way.
So you're not the first lawyer who's wanted to cross-examine the 45th president. There are a couple others who have said that they would welcome the opportunity. And one of my guests said O.J. Simpson at one point, and I said, "Why O.J.?" And her response was, "Because I could get him to confess." So,
Okay. All right.
So Dean, tell me, first of all, it's been a real honor for me to have this chance to chat with you. I know it's been longer than you probably had expected it would go. But tell me what's on the horizon for you. What lies next for you? I know you're in Chicago now doing, I think you're teaching now. Is that where you're at in Chicago? And then you go back to practice the other half of the week. Is that about right?
Yeah, I'm practicing about 20% of my time and teaching full time. And that feels like a pretty full life when you add in writing, because I'm really getting a chance to write more consistently now. It's in a sense part of my day job now, rather than being, put at the edges of the day and the weekends. I still do have cases. I don't want to stop representing people and having that direct engagement with clients. So I'm enjoying all of it, Neil. I really do enjoy the teaching and trying to meet students, people, almost all of whom are younger than me now, and some of them quite a bit younger than me, trying to meet them where they are and get a glimpse of where this profession will be 20, 30, 40, 50 years from now.
If somebody wanted to read anything that you've written, whether it's a practice manual or whether it was actually a nonfiction book, or if it was fiction, just about where would they find it and how could they go about trying to get your writing in their hands?
I like my second book. It's not perfect. I hope the third book will be better, but I thought the second one was a little better than the first book, which is the way it should be, right? So the second one is Keep the Wretches in Order. And I like that. I mean, it's about a very troublesome federal trial in 1918 in Chicago, with the judge, the man who 4 years later became the first commissioner of Major League Baseball, Kennesaw Mountain Landis. I've got a book chapter coming out in a year or so that allows me, it's in a collection, my chapter is just one of many chapters, but allows me to say some things I want to say about our criminal enforcement system from loosely a perspective of a Catholic. And I don't think of myself as a Catholic anymore, but from the perspective of Catholic social justice and Catholic dogma. I've enjoyed writing that chapter, and looking forward to it being out sometime in 2022. But I like the law. I've enjoyed writing the law review articles that I continue to write. But I guess I think my second book is sort of the longest and deepest dive of the writing that I've done so far.
And are you on a speaking tour or speaking circuit still, talking about any of these subjects, or the documentary or the case or anything like that?
No, the speaking is down to probably 2 or 3 or 4, maybe 5, engagements a year. It's not anything like a tour anymore. That went on, for a surprisingly long time. And there really was, that's my sense, that there was deep public interest in, the work of courts and the enforcement of criminal laws, triggered in part, but not exclusively, by Making a Murderer. And that, that zeitgeist, swept me up in it because I was associated with one of the documentaries that helped, form that zeitgeist.
And if people wanted to find you, if they wanted to learn more, I know there are websites out there where they can locate you. Would you just tell us how they could find you, either on social media or on the internet?
You can't find me on social media. I have literally no social media account, and I never have. But my email addresses are easily found by Googling me, either at school or at the law firm.
So, Dean, it has been a real honor, and you've been a terrific guest. I've probably taken you way over what you thought you would be committing to when we started to talk, but I'm one of those guys. I'm sort of a law nerd, a law geek. I could talk about this stuff, like all day. So, I'm rare in that way. To me, that I like watching law movies. I like reading law related books. I like reading, I love watching real trials, even though I know that they can be boring to most people. But to me, it's like, watching baseball, but I'm not a baseball fan, but if I was, that's what it'd be like. I just like all of it. And so I appreciate great lawyers, and you certainly fall into that category. So I want to thank you.
I feel really honored that you asked me to appear, Neil. I really do. You weren't trying to flatter me, but
No, I wasn't.
I
say that.
Feel honored. So thank you for having me.
I say that because this has been, you probably don't know, this has been a real, this has been a privilege for me. Doing the podcast in general. I began calling my style of cross-examination killer cross-examination because, we want some cases and some witnesses, like in the middle of a cross. Just, one time in an arson case, they went home for the day, and then I get an email from the prosecutor saying that I'm dismissing the case. And I'm like, what do you mean you're dismissing the case? We're like right in the middle of the trial. And he goes, yeah, the expert, he's folded. He says no more. So I started calling it that. And then I started calling it that, and then started sharing little snippets from transcripts. And then had a couple of pretty, big trials that ended up, we got, where people saw the style in court. And then I had the opportunity to start to do these podcast interviews. And like I told you, I'm not making this up, I really am a law nerd. Like if you sent me a picture of yourself with an autograph saying, it would be on my wall. Is the second it hits the second it gets to you're laughing. Ask anybody that knows me. The second that it gets to my office, it's getting framed and matted, and it's going on my wall. I've got a picture of F. Lee Bailey signed on my wall. I've got Jerry Spence on my wall. So meeting lawyers like you and them has been incredible. It's like going to fantasy baseball camp. And I know you are not one to give yourself as much praise as I think that you are worthy and deserve, but I'm telling you, it's been an honor to, meet the guys that I look up to and read about, and that I think are awesome lawyers who handled major cases. And so it's been my honor. So,
Thanks for finding a place for me on your roster.
oh, you're on it. You're on it. All right. So I appreciate it. That's Dean Strang, who's joined me on another episode of the Killer Cross-Examination podcast. And thank you for joining us and tuning in.